Ms. Hill, what is collateral estoppel?
Collateral estoppel. I think collateral estoppel, well, Senator, I will say that my 20 years of practice has primarily been dealing with issues relating to criminal law or relating to other areas of the law.
Yes,
and
ma'am. If you don't know, just tell me.
I certainly do know collateral estoppel. I'm finding that the bright lights of the moment are making it hard for me to recall it.
Okay, so you don't recall it. Okay. What is the amount in controversy requirement?
The amount in controversy requirement is $75,000. It typically governs, in many cases, almost any case in diversity jurisdiction in the federal courts.
Okay.
And in certain other.
What does the 13th Amendment to the Constitution do?
It outlaws slavery.
What does the 7th Amendment do?
It ensures that all civil jury trials, that all civil cases in the United States are done by jury trial. That you have a right to a jury trial in a civil case.
Okay. What is the difference between a stay order and an injunction?
A stay order would prohibit, an injunction would restrain the parties from taking action. A stay order, I'm not sure that I actually can give you that.
Tell me about, you'll see a lot of this in federal court, tell me about the multi-district litigation statute.
So I'm not extremely familiar with the multi-district litigation. I do know that multi-district litigation is often consolidated into a particular court. So all of the cases involving a particular type of issue, if there is a multi-district litigation, those will all be referred to one court and one judge who will then oversee the MDL. But I will confess I'm not super familiar with all the ins and outs of that.
Okay, what kind of constitutional claims are subject to intermediate judicial scrutiny?
Cases involving certain types of classes, such as gender or illegitimacy, are subject to intermediate scrutiny. Some types of speech, like commercial speech, would be subject to intermediate scrutiny.
Okay. Tell me what a 12B6 motion is.
It's a motion to dismiss a claim, a motion to dismiss an issue for failure to state a claim.
Okay. And what's the standard for granting a summary judgment in federal court?
It says that there are no issues of material fact, and that the issue can therefore be decided as a matter of law.
Okay. What's the standard for deciding whether a particular punishment is cruel and unusual under the 8th Amendment?
So the particular standard the court has said, and I cannot recall the case, but it says that you have to look at not only whether it is would be shocking to the individuals at the time that it was written, so it's not purely a historical review, as some of them are purely historical, but also you have to look at how it has changed, how those values have changed with time. It's one of those cases, circumstances where the court says it's appropriate to look at how values have changed with time.
Well, our right against cruel and unusual punishment is a fundamental right, is it not?
It is.
Okay. How do you square what you just told me about the 8th Amendment with the case after case after case by the U.S. Supreme Court that says the definition of a fundamental right is one that's explicitly stated in the Constitution or deeply rooted in our history and tradition?
Yeah, I think that it is. I think it is deeply rooted in our history and tradition.
Yeah, but certain forms of punishment are not. If a form of punishment, it existed at the time of our founding, and it's deeply rooted in our history and tradition, you telling me that makes it automatically constitutional today? I thought you just told me.
No, I'm certainly not saying that. What I say about it is really quite irrelevant, but the Supreme Court has said we look at it with a view to the changing values on these issues.
Why the difference? I thought
they're
both fundamental rights. Why the difference?
You know, I think that's a question that the Supreme Court's going to have to answer, whether or not they
I
have,
think it has. I'm just asking if you know.
I think I've answered the question to the best of my ability, Senator.
Okay. Thank you all.
Senator Hawley going to return? No. I think that all the senators have appeared who are going to question today. Ms. Hill, I congratulate you on surviving the John Kennedy 6-minute bar exam.
My contracts teacher is going to be appalled, and I'm going to have to live with that, Senator, but thank you, Chair. Thank you.
If you promise to spare Ms. Hill, I'll...
Did the White House give any of you any written materials to use to prepare,
They gave,
or digital materials?
they gave us, you know, questions, previous questions that had been asked by the panel.
And answers?
I think we had to go find the answers ourselves. I think we had to go watch the various committee
May I have a
meetings.
copy of that?
I don't have one, but I'm sure that it is literally just a list of questions.
I don't have a copy.
I don't have any of the
Would you
copies.
send me a copy? I'm easy to find. Would you send me a copy, Ms. Hill?
I will.
Okay. Would you each send me a copy?
Yes,
So I can
Senator.
compare and make sure they're all the same. Okay. Thank you.
As you know, in 2020, in the McGirt case, the Supreme Court held that in unique circumstances, major crimes committed in Indian country can be prosecuted only by tribal or federal courts. This ruling removed the state's ability to prosecute those crimes in those circumstances. Now, you strongly support the McGirt decision, and it's important to keep in mind that in Oklahoma versus Castro Huertas in 2022, the Supreme Court clarified that states retain the authority to prosecute non-Indians who commit crimes against others, even if those crimes take place in Indian country. Now, in one of your many critiques of that decision, you called Castro Huertas, quote, a very negative decision. And you said that, quote, Kavanaugh's opinion, which of course was the opinion of the court, Kavanaugh's opinion, it was terrible. To justify that critique, you came up with a hypothetical in which you stated that, quote, a non-Indian steals a car from an Indian, and that person can be prosecuted by the state. That person can also be prosecuted by the United States. They can be convicted twice for the same act and serve 2 sentences. That was part of your critique. My concern is that your critique here demonstrates a fundamental misunderstanding of how the double jeopardy clause of the Fifth Amendment works. I think most first-year law students can tell you that double jeopardy prevents separate prosecutions for the same offense when those prosecutions are brought by the same sovereign. A non-Indian who steals a car from a non-Indian, for example, in Utah, is properly subject to prosecution by both state and federal authorities, by the state government and by the federal government, because they are separate sovereigns in our system, just as in any other state in the United States. State governments are unique. They are unique independent sovereigns, separate and apart from the federal government. And the federal government is a completely different sovereign. This has been a line of authority. This has been a principle that's been clearly established ever since our nation's inception, certainly ever since we adopted the Double Jeopardy Clause in 1791 as part of our Constitution. So yes, McGirt presents a unique set of circumstances, an Indian committing a crime against an Indian in Indian country. But nothing in the Constitution prevents a state from prosecuting a non-Indian for their crimes, regardless of who the victim is. So in your view, do you disagree with the characterization of double jeopardy as I've just stated it? Do you disagree that the states are separate sovereigns from the federal government for purposes of the Double Jeopardy Clause?
I certainly don't disagree with that.
And if confirmed, would you follow the majority opinion in Oklahoma v. Castro Huertas?
I absolutely would. And, given the practice that I've had, I've been following it for some time.
Your apparent desire to remove the state's authority to prosecute non-Indian offenders would, in my view, only weaken law enforcement's ability to remove violent offenders from the streets. And it's dangerous to place loyalty to any particular group over your loyalty to long-established principles of law or of the Constitution. So am I misreading your statement regarding Castro Huertas or the hypothetical?
I think that the full context maybe is not really reflected there, the full context of my comments. I can say, certainly on behalf of my client, I was critical of the decision in Castro Huerta because it was a decision that had other ramifications in Indian law outside.
Right, but I'm not talking about the other ramifications. I'm just talking about about double jeopardy here.
Right, I understand that. But those ramifications, that was some of the context of my criticism of it. I certainly believe and understand that I'm required to will be required to follow the law if I'm so fortunate as to be confirmed to serve in the Northern District. And I understand the distinctions that if you have three sovereigns, that all three sovereigns could bring those claims, and there would not be a double jeopardy issue.
Okay, while you were while serving as Attorney General of the Cherokee Nation, did you state that you had no intent to enforce the law post-Dobbs?
I never said that.
Did you at any point say, I expect, and I think everyone expects, massive constitutional challenges to that law, just for your awareness, referring to those laws?
I was not referring to Dobbs. That was the decision of the court. I was talking about the Oklahoma law that had been passed relating to abortion post the decision in Dobbs, and that law was being challenged, had already been challenged in the courts. It was significantly newsworthy in Oklahoma at the time that the Oklahoma law was being challenged.
Challenged post-Dobbs on grounds that you believed were legitimate challenges post-Dobbs?
I couldn't say that they were legitimate. I just knew that there were likely to be many challenges to it. It was very contentious.